numbers 11 and 12, Andryeyeva versus New York Healthcare, and Moreno versus Future Care Health Services. Counsel?
Thank you, Your Honor. Judge DeFiore, members of the court, may it please the court. My name is Sari Kolach. I represent the appellants New York Healthcare and Murray Englard in the Andryeyeva matter. May I reserve 1 minute for rebuttal?
You may.
Thank you. The Second Department abused its discretion by failing to defer to the Department of Labor's...
Before we go any further, counsel, just explain to me, what's the purpose, the underlying purpose of the 13-hour rule?
The purpose is that the employees are paid for the time that they're working, but they're also given an opportunity for sleep and meals where they're not working, where they're relieved of their duties. They have to remain in the premises, but other than that, they're relieved of their duties. So they're only paid for those hours in which they're working.
When you say they have to remain in the premises, flesh that out a little bit.
They have to remain, if they're assigned to someone's apartment or house, they have to remain in that.
And that is because?
That's because that's the assignment. The care that person needed required someone in the premises, but didn't require 24-hour care. So it didn't require, there was an assessment done of patients, of clients, and if they're able to have someone with them during the day where they're attending to their needs, taking them for a walk, assisting them in dressing, helping them eat if necessary, but they didn't require around-the-clock care where they're up all night, or they had nursing where you needed to tend to them at various points during the night.
Doesn't this boil down to whether the DOL's interpretation of available for work is or is not irrational, completely irrational?
It does.
Isn't that what this? There's a lot of stuffing here.
Yes.
There's a regulation, and then there's all kinds of interpretations of the regulation and everything. But is it? Am I oversimplifying it?
Not at all. That's exactly what it boils down to. The wage order unquestionably.
So what is the definition of available for work?
Available for work is well, if I can sort of reverse that, Your Honor. What is not available for work, according to the wage order, is the time that you're sleeping. You are not, according to the wage order.
So do you know any firefighters?
I do not.
Do you know any firefighters?
I do not, but I know the distinction.
Do you have any relatives who are firefighters?
I do not.
No. Well, every firefighter I know has slept on the job.
Yes.
But nonetheless, when that bell goes off, they're available for work.
Yes.
And so the distinction that will be drawn, I think, is that they're there when you need them, and they're required to be there. Aren't these employees the same?
No, actually, I would make a distinction, Your Honor.
Well, let me just finish on that analogy then. So you're an elderly person, you have problems, you can't get up in the middle of the night to go to the bathroom. Who gets up with you? This person, right? This employee.
Well, it could be. The distinction with
no, come on. Now, when somebody's staying in my apartment, they're a home health care aide, I have to get up in the middle of the night. Who gets up with me?
If someone needs to get up with me. There's no saying that every client
Exactly, and when the alarm goes off, the firefighter, there may not be an alarm that goes off all night, but nonetheless, when that alarm goes off, that firefighter gets up. Isn't this the same kind of thing? Doesn't that person have to be there? They can't leave there.
Can I make the distinction between the
Sure.
two? The distinction between the firefighter, it is fully expected that fires could take place at any time of the day or night. Mm-hmm. And so you work a 24-hour shift as a firefighter. I did it when I was a riding DA in the DA's office. Mm-hmm. We worked 24-hour shifts, 2 in the morning, you got called to a precinct, you went to a precinct.
Sure.
You didn't get called, you slept on your supervisor's couch. Mm-hmm. But it was expected that you would get called. Here, it's expected, the plan of care and the people who are given home attendants that only work 13 of the 24 hours, it's expected that you'll be able to get those 8 hours sleep, if you can.
The two named plaintiffs here put in affidavits and also testified that they essentially never got the 5 hours. So why isn't a class certifiable on that somewhat different ground?
For 2 reasons. First of all, one of the named plaintiffs is not a class representative. She predated the class period. The other named plaintiff testified differently than her affidavit. At deposition, she testified that sometimes she did get uninterrupted sleep. In her affidavit, she subsequently said she never did. But that's just those two. We don't know if every other member of the class was able to sleep every night. You can't, and that one plaintiff.
But what they're
should-
claiming is basically a pattern of practice by your client, by the employer, and that's the quintessential class action type of claim. But let me ask you something else, going back to the firefighter. A firefighter is on a salary, correct?
Honestly, I don't know. I mean, I'm just not, you know.
All right, well, your employees are on a wage, or are they on a salary?
They are paid for every, they're on a wage. So if they work a
An
shift, they're
hourly
paid.
wage, because it's the labor law, it's an hourly payment schedule under that wage order, right?
It's either an hourly or for the 12-hour shift, you're paid X amount, which covers
Which
more than
works
minimum
out
wage
to at
per
least
hour.
being
Yeah.
whatever that
Yes.
minimum wage would be. Well, for 13 hours, you can't slight them for
Right.
less than that. So, but you concede that if at any point in time, any of your employees actually don't get 5 hours of uninterrupted sleep or the meal break, you got to pay them for each hour of that 24-hour shift at whatever is the appropriate minimum wage under the wage order, correct?
Yes.
Okay. So if they were able to establish that, you owe them that money, that's correct?
If each individual plaintiff could establish that they didn't get sufficient sleep and mealtime on each of their shifts, then yes.
Yes, okay.
But there's no evidence of that. There's one plaintiff who's a named plaintiff who worked for one person for 6 months. She worked 24-hour shifts. You can't extrapolate that to a whole class for a 12-year period.
Thank you, counsel. Counsel?
May it please the court, my name's Aaron Schlesinger. I represent the appellant Future Care. And I'd also like to reserve 1 minute for rebuttal time.
1 minute, sir.
Yes, Your Honor.
Please proceed.
I think a couple important points to note on this case are, A, that the Department of Labor is the agency charged with interpreting the labor law, and what they did was they rendered an interpretation for the industry to follow, stating that
Counsel, my problem with that argument is they issue this wage order, and that has this term in it, available for work, and in that regulation, which has the force of a regulation, they drop an exclusion for residential employees under a however. So they have available for work, and then they have a however. Seems to me pretty clearly to indicate the definition they understand from this regulation for available for work would otherwise cover residential employees. So I'm having a hard time understanding how later you can just issue an opinion that says that available for work doesn't cover the category of employees we're talking about now. Because the Department of Labor's understanding of that term from their own regulation was that it otherwise covered residential employees. So what possibly could be the consistent definition of that term that covers residential employees, because you had to drop an exclusion in the reg, but doesn't cover these, let's call them 24-hour shift employees?
I think we can all agree that the exemption applies to employees that physically reside at the home of the employer. I think we
Right.
all agree to that, correct?
But we also, I think, have to all agree that otherwise, those employees would be covered by the definition of available for work in the reg.
But if you take the job functions and the circumstances with regard to the employees that reside at the home of the client and those that do not, they're exactly the same.
Yeah, so
And-
you would have had to carve them out from the definition in the regulation.
Well, they should really both be subject to the exemption, because even those employees that physically reside at the home of the client, if the client is ill or injured or wakes up in the middle of the night, they're going to have to tend to that individual
But
too.
you've got a carve-out for them under the regulation, so they're not covered. But now it seems, and we can ask the Department of Labor this later, but now it seems as if the Department of Labor would like to cover some other employees without having to carve them out of their statutory definition by somehow changing that definition through an opinion. And I don't see any basis in administrative law or deference for being able to do that.
Well, again, the Department of Labor is the agency charged with interpreting and implementing the labor law. I mean,
They can't be inconsistent in their own interpretations, I think, is also black letter law, right?
it is, but we're here to stress the point that their interpretation is not inconsistent, because with both sets of home health aides, the ones that live at the home of the client and those that don't, they have the exact same work functions, they take the exact same breaks, they provide the exact same care, subject to the same plan of care, and when those clients wake up in the middle of the night, both home health aides are obligated care for them.
But I think, and I know we're kind of passing the night here, but to me, that proves that otherwise they would fall within the available for work definition that's in the reg, and so would require a regulatory exclusion as the residential employees did. Since their job functions are essentially the same, I don't know how you could specifically carve one out of the definition in the regulation and then do the other one by opinion letter.
Right, and that's why it's unclear, and that's why the Department of Labor has come in and for several decades has interpreted that regulation to apply to both home health aides that physically reside at the home of the client and those that do not. Secondly, with regard to the industry, it was their practice to follow the Department of Labor. Again, they're the agency charged with interpreting and implementing the labor law. So, if there's any specific agency that you're going to follow for advice on when to provide overtime or when to pay a home health aide over the course of 13 hours, it's them. It's not like the industry listened to someone off, some person off the road that just gave them, faulty advice.
And Labor Department has enforcement authority, right? Then they can go after home health care providers for violating these wage orders, right?
They can, yes, Your Honor.
So it seems like what you're saying would be a very good defense if the Labor Department came after one of these providers, and they could say, you're the agency charged with telling us what to do here, how can you fine us, how can you take an enforcement action against us? But would that same logic apply to not paying people who are otherwise should have been paid under the reg?
Again, the Department of Labor is the agency charged with interpreting the labor law to the public, and that is the correct agency for these businesses to listen to and take guidance from, and that's what they did. Again, it's not like they took it upon their own initiative to say, you know what, let's come up with this 13-hour rule. The other thing I want to say is that Medicaid and Medicare reimbursement also follow that advice given by the Department of Labor, and they only reimburse for 13 hours of a 24-hour shift. And
So the core of your argument, though, is that if there's an error, it's because we're following DOL's direction.
right, it wasn't taken upon the industry to come up with this idea by themselves. They took it from the Department of Labor, and if you're not going to take it from the Department of Labor, who else are you going to take guidance from on the labor law?
Thank you, Mr. Schlesinger.
Thank you.
Counsel?
Judge DeFiore, and may it please the court, my name is Jason Rosger. I represent the plaintiffs and certified class in the case of Andryeyeva. My first point is there's a world of difference between a residential employee under the wage order and a non-residential employee, and that's very clear from the record in this case.
And what category are home health care aides?
Non-residential. Okay. They're spending 3, 4, 5 days a week in the home of their patients, not the home of the employer. Correct. And that's the settlement home care case. And I don't think that is being disputed here.
Right, so then they don't fit the however clause. They don't fit.
Correct.
Under the wage order, any description about residential employees.
Correct.
So then they fit otherwise, as Judge Garcia was pointing out, to whatever else this wage order says, correct?
Yeah, that's correct.
Okay.
And
So then why is it that the DOL is, in your opinion, not able to interpret available for work at a place prescribed by that employee to mean the hours that you actually work if you don't get the sleep and meal times?
Because the home attendants are available whether they're awake or asleep, eating or not eating. There's plenty of evidence on this record and in the record Moreno case that.
Yeah, but as I
anytime-
understand the DOL's position, the position is that if they sleep the hours that the DOL has already identified, the 5 hours uninterrupted, although they do obviously point to 8 hours, but they talk about the 5 hours uninterrupted, and they have a meal break, that doesn't constitute availability.
Well, that's contrary to the record in this case and to any reasonable explanation of the word available, as the Second Department found. When you're available, you're ready to go. Dictionary definition is present or ready for immediate use. And if they're sleeping, however many hours the home attendants are sleeping, if the patient needs their help, they have to get up right away and do it. If they're eating something, they have to stop what they're doing and help the patient.
Okay, so then explain why Judge Cote is wrong in Severin, that your interpretation means available for work is superfluous.
Two things about the Severin decision.
Yeah.
One, didn't have the benefit of the 2 appellate division decisions that came down later. But what Judge Cote misunderstood is what available means in the context of the home attendants. Judge Coates said that they're not available during the time they're sleeping or eating. And that's just not the case. It's not the case on this record. Anytime you're sleeping or eating, you're available. The home attendants have to get up. Ms. Odress testified that she was afraid to sleep because her
I think the
charge
point is if they actually sleep and if they're actually on a meal break,
Right.
then no,
Remember-
they are not actually working and available.
Well, I think that's actually not true, just quite frankly. On a meal break, there's lots of evidence.
But the
that-
question is not the one I think you're posing. The question is whether or not the Department of Labor's interpretation, their construction of their regulation that has been longstanding for decades, is irrational and reasonable.
I would make two points.
Given the way home health care aides work, given that particular work industry.
Sure. Given how home health aides work, they are available whether sleeping or eating, and therefore it is unreasonable or irrational. I also want to push back.
But you agree
against
that it is possible, of course, that during the course of a night, the home health care aides' sleep and meal breaks would not be interrupted by a patient. You agree that that's possible, correct?
It's theoretically possible, sure.
Because otherwise, you would be arguing for someone to literally be awake for 24 hours.
No, we're not arguing for that, and we don't have to argue for that, because as long as they are required to wake up and provide aid when needed, they are available under the regulation.
Well, let me ask this question, just to follow up with Judge Rivera's question. The way it's posited this 2010 opinion letter, which set out an interpretation that the industry has been relying on, that establishes this 5-hour uninterrupted sleep, 8 hours total, 3 hours of lunch. The question as to whether or not it's possible that it could happen, wouldn't that go to a summary judgment motion or a finder of fact and not go to the class certification question?
Potentially, yes.
So, how
What I would
so?
s-
In other words, what I'm wondering is these factual questions, which reasonably on both sides, there are factual questions, they may exist, but how does that affect this class certification, I guess, is what I'm wondering. Since normally in the class certification, we take these facts that are put forward and just to try and determine if they meet the 5-part threshold. And if they're uncontested at this point, it seems unquestioned that they do meet the threshold. So tell me if what your take on it is.
Well, my primary take, of course, that the second department is correct and that all we need to show
We
is show
figured
24
that.
hours. full
We
stop,
figured that.
Right? If we do have to get into how much sleep or mealtime people are getting, there's certainly ways to do that on a class-wide basis. The way that patients are assigned either a 24-hour care or 12-hour care.
In the initial determination, was any effort made to show that it wasn't true? That as a matter of fact, that people were sleeping 5 hours a night all the time? And the industry came in, or the defendants came in with proof saying, no, we have all this proof that these people are getting 5 hours sleep a night, and there's no question that this has taken place, and this certification shouldn't take place, Your Honor.
Yeah, there was no proof of that in this case.
Was there any proof offered at all on that point?
What is undisputed is that the employers never tracked sleep time or meal time for the 24-hour home attendants. Home attendants have to call in.
So if that's correct, then is there any available proof at all to make that point?
I would say not in favor of the employer. If they had the duty to keep those records, then I think this class would still be available to the plaintiffs. That brings me to another point.
It does, but I want to stay with the certification point. So it would be inappropriate for me to comment on whether or not anything is being proven here, but what I'm wondering is was there any attack on the factual basis for the certification then, if that wasn't attack? And if there was, what was it from your point of view? Counsel can respond when they come up to it.
The court below really went just as far as 24-hour shifts need to get paid all minimum
Okay.
wage. That's
All
as
right.
far
No,
as it
thank
went.
you. That answers my question.
And I wanted to push back on this longstanding interpretation.
So aren't there these letters, memos, and remarks from 1980, 83, 84, 98, 2009, and 2010, which are sort of at odds with the position currently taken by DOL?
Yes, some of those remarks, some of those internal memorandum set forth this residential, non-residential distinction. So I think it's fair to say the DOL had a policy of making that distinction even from 1960. But what I also want to leave the court with is there's no evidence that they actually relied on this stuff. Not no evidence, but if you don't keep track of the sleep time or the meal time, why should we believe that the agencies were actually relying on this 2010
May I ask,
opinion?
how does one keep track?
There's a call-in system, and each home attendant has to, and that tracks when they arrive and when they leave. If there's a couple 24-hour shifts in a row, they call in the morning and at night, and just to sort of reset the system. They also have to enter data about what work they did. Did you change the patient? Did you do her nails? Did you wash her hair? It'd be very easy to ask, how much sleep did you get last night? Press the number for number of hours.
Oh, no, I'm sorry, I wasn't clear. Thank you for that answer. What is it that they now do? They call in and they say, I've arrived, and when they leave, they call in and say, I have left,
Correct.
and then in between hour 1 and hour 24, what do they do?
They don't call in. They're taking care of the patient. At hour 24...
So at no point in time do they indicate, I am now going on a sleep break, I am now going on a meal break?
Correct.
Did the employer ever require them to do so?
No. And they could have, which makes me very suspicious that they were actually relying on this supposed opinion letter.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Judge Giafor, members of the bench. My name is Mike Sweeney, and I represent Ms. Moreno and Ms. Peguero and the class in the Moreno action.
Mr. Sweeney, could I pick up on this? Because there are a number of different issues here. And one of them is the interpretation, the DOL's interpretation of the reg. And another one is whether they meet the requirements for class certification. And then there are a bunch of sub-issues underneath that. But I'd like to know if you would agree with me that even if there is evidence that the employers, or at least these employers, we don't necessarily know about all employers, but these employers aren't following the rules, does that have any bearing on whether the rules, the DOL's interpretation of the rules, are rational or irrational?
Well,
in other words, those are two separate questions, right?
Yes, I would say this. I mean, whether or not the court finds that the DOL's interpretation is appropriate or not, there certainly still is a class issue here as to whether or not the policies and practices of these defendants in this case actually meet that regulatory requirement.
You mean even as interpreted by DOL?
As interpreted by DOL or interpreted by the courts. I mean,
but sticking with, if we assume for a moment that DOL's interpretation is not irrational, so let's just hypothetically assume we're stuck with that. The thing that I thought, maybe I'm wrong, and correct me if I am, that was different in your case from Andryeyeva is that your two plaintiffs did not allege that they never got or didn't usually get the 5 hours of sleep, and there wasn't either pleading or evidence like that in your case. Is that right or wrong?
Your Honor, there is an allegation of class-wide practices. There was not testimony from the individual plaintiffs. You're correct.
What was the allegation? What practice?
The allegation, the class-wide practices were that they did not pay for all the hours that were worked, that they did not pay overtime wages, that they did not pay spread of hours wages, that they did not pay the wage.
So I'm asking more specifically, was there an allegation that the members of the class did not, as a regular matter, get 5 hours of uninterrupted sleep?
Was there an allegation in the pleadings? No, Your Honor, there was not.
And proof of that?
Yes, there is plenty of proof of that, Your Honor. I mean, the case has proceeded since then, and discovery has gone on. We talked about available for work. I mean, Ms. Moreno slept in a chair in her client's room. And when her client woke up, she was responsible for taking care of her client. That is quintessentially available for work. And what's gone on here is a medical professional has made a determination that this patient requires someone to be on premises 24 hours a day.
On premises, but not necessarily caring for them at all times. Isn't that what differentiates the clients that can have 24-hour care from the clients that have split shifts? Isn't that one of the differentiating characteristics?
Well, I think the characteristic, again, the 24-hour shift is a requirement that they're there available for work. I agree that there's
definitely a requirement that they're there, right?
Well, beyond that,
Okay.
available for work. right?
But I guess, to me, the available for work seems like it's a term of art, and that's what we're determining what that means, that it may or may not mean the same as the dictionary might, or what we might in common parlance think. And the question here is do we give deference to DOL in how it's interpreting that phrase?
So the Department of Labor is due deference for their interpretations of their own regulations where they're ambiguous. And we would argue that there is no ambiguity here. This is pretty clear, the language. It says if you're required to be available for work at a prescribed location. It doesn't say if you're not sleeping. In fact, as Judge Garcia pointed out, there is a specific exemption in there for sleep time. But that only applies to residential employees. These employees are non-residential employees. So I
is it irrational for the State Department of Law to interpret the rules the same as the Federal Department of Law interprets the federal rules?
It is irrational and unreasonable for the Department of Labor to interpret a law contrary to its plain meaning. The federal standard may be a reasonable standard. No question.
Is that regulatory, though? The federal standard that they defer to, isn't that by regulation?
It is by regulation. The problem on the federal side is there is no definition. There is no statute like 142-2.1 that describes, that tells you what work is.
Is that this is a regulation. They wrote it. It's their terms, it's their words. It's what Judge Garcia referred to as that carve-out they've got. But it's their distinction between residential and non-residential. It's their distinction between on-call versus subject to call. And the question boils down to, is it irrational and unreasonable? Because there's a lot of deference embedded in that phrase for them to have used this term and to interpret it as they have, which is, we assume that if you sleep and eat these required hours, no, you're not available because, of course, you will not actually work. But if you actually work and don't get 5 hours of uninterrupted sleep and the meal break, then yes, the employer must pay for every hour of your 24 hours during the shift. Why is that unreasonable and irrational?
Because it's contrary to the plain language of the regulation. Available for work, as the second department said, means you're there and you have to be available for work. These people are required to be there and they're required to be available for work.
So available for work is synonymous with on-call or synonymous with subject to call, or on-call versus subject to call is irrelevant?
So let me give you a distinction of on-call and subject to call. Right? You could take, for example, a doctor. Right? So a doctor may be at home on call in case she's called in to come and do some work. And in that case, they're subject to call. But that same doctor may be required to be at the emergency room, ready to take patients as they come in. That person is working. They may get some sleep on a couch. They may have an opportunity to have a meal, but that doesn't mean that they're not.
The problem with that analogy is what was raised before by the bench, which is DOL, based on its experience and expertise, has said, unlike an emergency room surgeon who will be called upon many times during the time that they are at that ER, a home health care aide may not have interrupted sleep or interrupted meal hours. That's the difference, and that's based on their experience, their expertise, the way they understand the industry. And why is it unreasonable and irrational, based on that experience and expertise, for them to read this way? I think my problem with your argument is that your argument, and it may very well be borne out, is that the defendants have abused their employees, that they have exploited their employees. But that strikes me as different. That's about enforcement versus what goes on here. If things are as you describe, there shouldn't be those 24-hour shifts. They should be on 2 12-hour shifts, or maybe they need 3 8-hour shifts, or even more shifts, right?
So I appreciate Your Honor's position. I appreciate that there is a tremendous amount of deference that goes to the Department of Labor. Nonetheless, there's a line. And the Department of Labor is not entitled to create an exemption to the law from the plain language of the law through its own opinion letters or through its own interpretation.
Let's clarify. There is the New York labor law, the statute that the elected officials have passed, and then it's this wage order, right? This is their wage order, right? Pursuant, I'm sorry, I can't remember, the Wage Act that requires the commissioner to pass these wage orders. This is their language, correct?
Yes.
So they're interpreting their own language. Let me ask you this. Do you concede that, let's say we held in your favor with respect to this interpretation. Do you concede that the day after they could proceed to pass a regulation, as they have tried with their emergency regulation, to actually define availability of work in the way that they have always interpreted it?
The Department of Labor can certainly promulgate a new regulation. To do so, it must go through the legal requirements to change the regulation, to change the minimum wage order.
Your position isn't that they could never actually take this position? Just that they have to go through the proper regulatory process to do so?
There's a clear process by which the Department of Labor promulgates regulations, and they must follow that. That's the law.
And now counsel will hear from the government. Thank you.
Thank you.
May it please the court, Stephen Wu for the Department of Labor.
Take us through, counsel, your interpretation of the wage order, getting straight away to available for work.
Well, absolutely, and let me begin with the purpose of this rule. I mean, the purpose of DOL's longstanding policy is to identify the quite narrow set of circumstances under which the ordinary rule that idle time is compensable time
Let's take a step back. Excuse me, Counselor, before you do that, let's take a step back for a second and clarify what you're talking about. You are not talking about, when we talk about this 8 hours sleep or 8 hours work during the night and 5 hours uninterrupted sleep, what we're talking about is an opinion letter. We're not talking about a rule, a regulation, or any statutory requirement, are we?
Well, it's a series of interpretations and enforcement guidelines.
I understand that, but in essence, it culminates in a 2010 opinion letter. It's an opinion letter, right?
The 2010 opinion letter is part of that, but I want to be clear that it is routine in the labor area and both the federal and state level.
No, that's not my question. You can say all those things, but I want to be clear as to what it is.
Correct. These are a series of enforcement guidelines and opinion letters that interpret the underlying statute and the wage order.
We see these all the time. We see them from the Attorney General opinion letters. The court, of course, has to take notice of them, but they are not entitled in any statutory construction standard to the kind of deference that I would give to a normal regulation. And you aren't arguing that here today.
And we are not. And I think the case that I think answers that question quite directly is the Supreme Court's decision in Skidmore, which was about a federal Department of Labor interpretation, quite like this one, arose from a series of informal enforcement guidelines. And that's the origin of Skidmore deference in the federal courts, which is to defer to the expertise and experience of the agency, given its persuasiveness, consistency, and history.
Of course, you're the people who do it every day. Of course, we should listen to you. That, however, is not the same as the kind of mandatory deference that we would be required to give. And you aren't asking us to do that here.
We are not. And that is part of the reason why we think the length and vintage of this history is important for our deference argument.
Go ahead, Mr. Wu.
And on the question of what this criteria is intending to accomplish, it is to identify those circumstances where meal breaks and sleep breaks are regularly scheduled, substantial, and meaningful, so much so that it is reasonable for the department to conclude that the time spent on those breaks is really for the employee's benefit and not for the employer's. And in that sense, as a practical matter, the employee is not available for work if the employer honors the restrictions that the department has imposed.
Can you try then to answer Judge Garcia's question, which is, the statute looks as if it has a specific exclusion that applies only if you are residential, which at least arguably implies that if you are not residential, if your stuff is somewhere else, you don't get the benefit of the exclusion and the rest of the statute applies.
So there's a couple of answers to that. And one is that in the speech that's on page 119, 120 of our addendum, it was explained that that was in the wage order because at the time residential employees were common. And the type of arrangement we have now, where you have a third-party employer of individuals sent to clients' homes, didn't really exist. I think that's the explanation for why that specific provision is in the wage order. But the other and broader point is this, that the wage order has never been understood to be sort of the four corners of the department's policy when it comes to compensable time. I mean, there was earlier discussion of subject to call and on-call and that distinction, and that distinction between sort of the gray area where somebody is working or not working is not contained in the wage order either, and yet is a well-established feature of compensable time.
I have a problem with that. I mean, this is a wage order. It's promulgated through a specific process that's spelled out, and it tells people, you're working 24 hours, when are you going to get paid? But now you're saying, no, it's not the four corners. We can have a speech, or we can have a letter, and that will knock off, 45% of whatever time you're there. One, I have a problem with deferring to that type of an arrangement. But two, I still don't understand how within a regulation you can have a term available for work where, as an agency, you felt it necessary to carve out sleeping time within the reg, because otherwise it would be covered by available to work. But now in an opinion letter, you're saying, no, available for work doesn't really mean that you're sleeping. As long as you're sleeping. But here you assumed available for work when you covered you got paid when you're sleeping because you had to carve it out.
Well, and I guess my answer is this. We don't think the residential employee provision is a carve-out. It's a clarification. The word however there is really to avoid any doubt about how you might apply this provision. And the department has consistently said and has interpreted the phrase available to work or required to be available to work
I think it's
separate from
almost
residential
a more
employees.
difficult argument to make, because someone who's living on the premises, you can almost see saying that's your normal sleeping quarters. So when you're sleeping, you're there anyway. You live there. But now you needed to, however that. Now you're saying, no, you were sent there by your employer. So all things being equal, you're not sleeping in that chair. But because you get to sleep in the chair, we're not going to pay you for either that time.
Well,
and that would seem to be a more necessary carve-out from your definition than even what you have.
Well, and I think that's part of the reason why the department has been consistently issuing these guidance documents and opinion letters almost contemporaneously with the wage order.
Why didn't you amend the regulation?
As I said, the department could, I think, has the power to do so. The longstanding practice in this area has been to proceed in the form of these informal enforcement.
How wide is the applicability of this? Does this apply to ambulance drivers? Does it apply to firefighters? Does it, are we limited here to home health care aides?
Well, so the origins of this rule comes from workers working 24-hour shifts, and the department made a judgment about the nature of the meal and sleep breaks that workers with 24-hour shifts will be undertaking. It was then applied to home health aides when they were brought under the scope of the Minimum Wage Act. And to defend the reasonableness of that interpretation, I think the judgment here was that when somebody is working 24 hours, they will have to sleep and eat sometime during that period. And the department will allow exclusion from minimum wage and overtime for those periods, but only when the employer adheres strictly to the requirements the department has imposed. And that's why, for instance, although the facts of this case are not something the department has investigated, sleeping in a chair next to a patient's bed is unclear whether that would comply with the requirement that there be adequate sleep facilities, which has been a feature of this part of the department's interpretation since its inception.
So can I just to be clear, with respect to the residential employee, this carve-out always applies? Is a residential employee never able to get paid if they too are disrupted in their sleep and meal patterns?
I think there's separate guidelines for residential employees that are interpreting this provision. I do not think it is a flat rule that they can never get paid for that period of time. And importantly, the policy for what are in this case non-residential employees and residential employees is consistent. The department is trying to apply the same principle across both of these categories of workers, namely, just identify circumstances where I think it's reasonable to think that the time is largely the employer's own.
In part, well, I know that you've argued in part there's a desire for the commissioner to align these rules with the federal rules, but I also want to ask, is this in part an attempt to recognize that you deal with the kinds of abuses that are alleged here through enforcement as opposed to a particular way of reading your own regulation?
That's exactly right. And one thing I do want to emphasize is that the department treats as seriously the exclusion parts of this, the narrow circumstance of this rule, as it does the exclusion. I mean, there are many situations where employers fail to satisfy the prerequisites for excluding this time. And one thing I do want to clarify, Judge Rivera, is that if the employer does not satisfy these prerequisites, it's not just the time working that the employee is compensated, but actually the entire 24-hour period. You get interrupted for meal times, you get that hour of compensation. You don't get the 5 hours of sleep, you get paid for the full 8 hours. So it is a hair-trigger application of these provisions to protect workers from the types of abuses that the department regularly sees.
Thank you, counsel.
Thank you.
Counsel? You're welcome.
I just want to address two quick things. You know, there's a lot of discussion about the distinction between residential and not residential. And the distinction is who the employer is. There's no basis in any regulation, any law, in any history, in any opinion letter that a residential employee otherwise lives at that as the premises. It just means that they're working for the person, their employer is the patient. And that's the person who pays them versus
the language in the regulation says a residential employee dash one who lives on the premises of the employer.
Yes, and then if you look at they do, because for those 24 hours, they live on the premises of the employer. As a non-residential, lives on the premises of third-party recipients.
So your interpretation of that language would be one who lives on the premises of the employer lives there for 24 hours when they have a 24-hour shift?
Yes, it's not just my interpretation. That was the interpretation of the Second Department in Settlement Home Care versus Industrial Board of Appeals. The issue there was...
If it was an 8-hour shift, would they live there?
No, because they wouldn't sleep there.
So
You're living in the court, Judge Garcia.
Right. No, it's if you work a 24-hour shift and you're sleeping there.
24 hours is the live there definition.
Because it's where you're sleeping, and in
But
settlement.
if you were there 24 hours and awake, then you wouldn't be living there.
If you were there 24 hours and on duty and awake, then I suppose you wouldn't be living.
Live there.
But Settlement Home Care specifically says you reside in the home of the third-party recipients of services versus residing in the home of the employer if you're employed by an agency.
So that's kind of here and there. It's a little bit of a red herring to me because the real issue is whether or not the Department of Labor has been irrational or unreasonable in its interpretation of the remainder of this particular wage order to treat home health care aides in a way that is somewhat similar to those who are residential employees. Not exactly, but somewhat similar.
But the only distinction is who their employer is. So whether I hire someone directly to be an aide for a family member or I go through an agency.
Yeah, I understand, but I just asked counsel for the Department of Labor, what happens when you don't meet these requirements for the residential employer? And he told me there's a whole nother bunch of regulations that apply to that individual. So that's why I say similarly, not necessarily exactly
I
the
understand.
same.
Okay.
But
I
the
understand
question
that.
is, if you have someone who is spending what otherwise would be their personal time to rest,
Yeah.
sleep, to eat, take a break, in that home, right? Is it unreasonable or irrational? I know your position already, but that's the question before us, right? For the Department of Labor to say, usually, we assume that person working under this environment, given our expertise and our knowledge about this industry, does get that break time. And if the employer doesn't allow that, or doesn't otherwise reimburse them, as he says, it's a hair trigger, they have to pay. And then they're subject to DOL enforcement and these lawsuits, obviously.
And that is not unreasonable or rational.
Thank you, Ms. Kolach.
Thank you.
Counsel?
Thank you, Your Honor. I'd just like to end by saying that the other issue that this court is going to have to decide is whether or not class action should be granted. I just want to say in the future care case, regardless of how this court rules on the exemption, plaintiffs did not meet their burden of proof to meet all the Article 9 factors for class certification.
Well, since, at least, you're talking about your case, but it's questionable about how the courts below looked at this because in one case it was the Supreme Court and the Appellate Division, in the other case it was the Appellate Division said that the 24-hour rule, that they were entitled to payment for 24 hours. So given that, would it not make sense to remit to one or the other of the courts to look at this in a fresh way?
The only reason that you would not have to do so in the future care case is because at the trial court level, 2 different judges upheld the exemption and gave deference to the exemption and already ran the analysis on whether or not a class action in this
Well,
case
except
is
Mr. Sweeney
appropriate.
says that there's a lot of discovery that's occurred since then. I mean, is there a reason not to let him try again?
There is, Your Honor, because when plaintiffs made their motion for class certification, they were provided with documents, they made their motion, they made their arguments, and they're locked into those arguments, and that's called preserving your argument. You're not allowed to bring new arguments on appeal.
But doesn't the statute allow plaintiffs seeking class certification or allow courts to modify the order, to give conditional orders and so on and so forth? So
It does, but
why
again,
shouldn't they have an opportunity to request that?
because in this case, not one but 2 separate judges ran the analysis providing deference to the exemption. Justice Schmidt?
Did Judge Nypel really run it again, or did, I mean, it was, if I recall, a renewal and re-argument, and basically...
It was, and both judges correctly held that plaintiffs did not put in the proper evidence to be given class certification. They put in conclusory affidavits saying, I was not paid my proper wages, I was not paid for certain uniform expenses, and I saw other people pick up paychecks when I was picking my paycheck up, or I saw them in classes, and therefore they too must have been wronged also. That's not evidence under the laws of this state, and therefore those statements were conclusory, and the courts correctly both stated that plaintiffs did not meet their burden of proof. They had their chance, they didn't put in the proper evidence, and it's too late now.
Thank you, Mr. Schlesinger.
Thank you.